You are now listening to the Fighting Back Podcast, and here's your host, Jessica Travis. Welcome to another episode of Fighting Back Podcast. My name is Patricio, a.k.a. Rocky, and I'm here with attorney Jessica Travis. How you doing, Jessica?
I'm good. How are you today?
I'm doing good. I can't believe I did that in one. But we are doing another Sidebar episode, and on this episode, we're going to talk about the list.
The list.
And
dun, dun,
yeah, ooh, you see, that's a sound effect I should have on the soundboard right there. But yeah, the infamous list that everyone's been talking about that no one's seen. Well, a few people have seen, but you know, it's being held back for a little bit.
I don't know what you're talking about.
We're talking. Can I say the name of the list? Would that be okay?
I think so.
All right. So we're talking about the Epstein list, and I mean, you can't go not even 5 seconds on social media or just the news in general without hearing something about the Epstein list and all the people that it's going to affect once it's out. But I want to talk to you about how and what the Department of Justice, their role is with all this that's going on. Like, can you like break it down for us?
Sure. And I mean, we'll start by saying we're sitting here in our conference room in Florida. Neither of us work for the Department of Justice.
Mm-mm.
Neither of us have worked for the Department of Justice. They don't include me in any of their conversations or emails about what they're doing and what's going on right now.
Yeah, we have no affiliation with the Department of Justice.
So everything that we're really going to talk about today with it is really going to be talking about the law in general. Mm-hmm. Right? Every lawyer has certain ethical and legal obligations under different rules and statutes and requirements. So I think this conversation really is more talking about the general legal aspects of the law and the different roles that attorneys and departments have in the justice system, and really not specific about what the DOJ or what the attorney is doing and whether they should or should not. Okay.
And what you just said right there, roles itself. So the one big role with all of this has been going on is Ghislaine Maxwell's role in all of this. And her talking with the Department of Justice under limited immunity. What does that even mean?
Yeah, so there are two types of immunity. There's transactional immunity and there's use immunity. Now, transactional immunity is a blanket immunity, and that protects witnesses from being prosecuted at all for any offenses related to their testimony.
Okay.
That's why we call it the blanket. It is broad. It is not used very often, and it's not used ever in federal court. It is used occasionally in Florida state court, but it's typically a type of immunity that is very rarely used because it is so broad.
The first time I ever heard the term immunity was from Lethal Weapon, and how the guy says, "I have diplomatic immunity. It's just been revoked." All that, like, what does that mean? Like, I know that's kind of like a little sidetrack of it, but like, does that fall into the same category or no?
Well, you'll be shocked to hear this, but a lot of legal terms that they use in the movies aren't real.
What?
Yeah. I know. So there is a second type of immunity.
Okay.
It is use immunity, sometimes called derivative immunity. This type of immunity is more common. It is used in federal prosecutions. It is also used in Florida state prosecutions. And basically with this type of an immunity, the prosecutor can't use the statements that the witness says against them, and they can't use anything derived from those statements. But they can still prosecute based on any independent evidence.
So it's kind of like when you're talking to a reporter and you tell them off the record, and you know they can't disclose their source, but everything else you can kind of work around, right?
Kind of. So the example that I like to use all the time is murder because it's easy to understand.
Murder.
Right? So for example, if somebody is given use immunity and they tell prosecutors, yes, I admit it, I killed this person, it happened, here's what I did, here's how I did it, completely killed the person. Prosecutors can't use that statement against the person because they were given use immunity. But if prosecutors find a video that shows that person murdering the other person, that's now independent evidence that can be used against that person for prosecution.
Okay, so it's kind of a loophole to the loophole itself.
Kind of. I mean, it's immunity in that the statements you say aren't going to be used against you.
Okay.
But it's not transactional immunity. It's not a blanket immunity. It is only use, it's only derivative immunity, so it does have its limitations as far as what you can be immune from.
Okay. So kind of going back to what the first part of it, like, Ghislaine Maxwell's role in talking with the Department of Justice and having this limited immunity, like what requirements does the Department of Justice have to disclose? Like she probably sang like a bird or said certain things, of course, under direction of her attorneys. But like now that they have this information, like what can or can't they do?
Yeah. So again, I don't know what's going on with her or with DOJ because I'm not her attorney. I'm not representing DOJ. So we can only guess.
Okay.
But what I can say is because she's given use immunity and she has a defense attorney who's representing her, I would hope that the defense attorney has gone over with her what exactly use immunity is, what can be used against her, what cannot be used against her, and how her statements will affect her prosecution. I'm hoping that they had that conversation before she talked to DOJ, and so she had a proper understanding as to what she was going to say and what those legal implications for her statements would be.
With the DOJ obtaining information like this or interviewing some of the statute, like does this like affect any other investigations that's by the FBI, the DEA, so on and so forth, or does that affect their investigations or no?
Well, if somebody is given use immunity, those statements can't be used against that person, but they can be used against any other person. So the immunity really is only limited to the person giving the statements.
Okay.
The statements can be used to implicate or as evidence of guilt in anybody else's criminal investigation.
Now, with her attorneys, I'm sure the conversations that are being held, and of course, attorney-client privilege, but like knowing, like what the ethics and the conduct, like do they come into question on something of this magnitude or no?
Don't know what you mean.
So, with her talking about this list and disclosing some information to her attorney, does an attorney have to like keep this completely quiet, even though it's like something that everyone wants to know about?
So when we're talking about disclosures, there are certain requirements that defense attorneys have for confidentiality, certain requirements that the Department of Justice or prosecutors have for confidentiality.
Okay.
So all attorneys are bound by the state bar rules of professional conduct for the state bar that they're licensed in. For example, I'm licensed in Florida, so I have to comply with the rules of professional conduct for Florida. All of the federal prosecutors and everybody who works for DOJ and is part of the U.S. Attorney's Office is barred in a state, and that state has rules of professional conduct that they have to follow.
Okay.
But the DOJ also has ethics rules through their Justice Manual. So this was formerly the U.S. Attorney's Manual. And this manual lists the rules that they have to follow for the DOJ and for the U.S. Attorney's Office.
Okay.
And Section 1-7.000 discusses confidentiality and media contacts policy. So that section really goes into what the U.S. Attorney's Office can disclose.
Okay. And I'm sure with the ever-changing world of, how would I say this like this? The technology, social media, and everything that goes on, I'm sure these rules had to have been adapted over the years.
I don't know when the last time that they were updated. A lot of times I think the law is responsive as opposed to proactive.
Okay.
I think a lot of time we see the changes in society and in life and then make rules to respond to those changes. But I don't know the specifics in this case.
Okay. Um, now with, like I said, going back to this list, everyone wants to see it. Everyone wants to know what's on it, who's involved, because I mean they're big players. They're big players in this game right now. But like how does this become unsealed? How does the general public or just the world in general at one point be able to get this list?
Well, it's really going to be based on whether the U.S. Attorney's Office voluntarily releases it or if there's a court order.
Okay.
So as far as disclosures from the U.S. Attorney's Office, most of the time, both state and federal prosecutors aren't going to disclose a lot during an ongoing investigation.
Okay.
Because they don't want their disclosures to hinder an ongoing investigation.
Ah, gotcha.
But there is such a thing as the Freedom of Information Act, which I think a lot of people have heard of it. And it's essentially a way that some documents are available to the public under that Freedom of Information Act. Now, I will tell you that any documents regarding an ongoing investigation are not. So those are not required to be disclosed.
So once the case is closed, then it could be unsealed, right?
So the FOIA, Freedom of Information Act, is very specific as to what must be disclosed and what cannot be disclosed. So you'd have to look up the specifics of what the Department of Justice has to disclose under FOIA.
Okay.
But if it is listed under FOIA as required to be disclosed, then the DOJ has to disclose it. But it is a narrow list. So Florida has the same type of list. So we have the Freedom of Information Act as well, where we are able to submit requests to any of the government agencies, the state attorney's office, the Attorney General of Florida, to get those documents under the Freedom of Information Act.
Could someone or an agency request cases from like high profile cases, like let's say the Watergate or the Clinton Lewinsky scandal? Like, would those be available if FOIA was filed on that?
So again, it depends on the documents that are being requested and whether they fall under that specific FOIA.
Okay.
I will tell you, for things like Watergate and for the Clinton Lewinsky, a lot of what was disclosed there was grand jury testimony. And that came through a court order. So there are times when grand jury testimony can be unsealed. So I'll start by saying most of the time grand jury testimony is confidential. It is sealed. The only people who have access to that grand jury testimony are prosecutors, the grand juries themselves, and the court. But sometimes in high-profile cases, the court has authorized limited disclosure for the public good. Those cases, such as Watergate, the Clinton Lewinsky matter, in those cases, the court did authorize limited disclosure of the grand jury testimony for those purposes.
Do you foresee at any point in the near future a court order to disclose these files, this list?
So I know that the Department of Justice, I think in Congress, are requesting for the court to unseal some grand jury information and some grand jury testimony. The court's going to have to do an analysis of that as to whether they should be disclosed or not. The analysis really is whether it is for a valid purpose and whether that purpose is unsealing the records is necessary for that purpose. So it's really hard to say how the court is going to rule on unsealing the records, what type of disclosure, if the court allows the grand jury records to be unsealed, which records will. They typically don't unseal everything. It's typically limited.
I was going to say, like, usually in cases like this, there's going to be a lot of redactions, huh?
They usually, if they are unsealing records, it will be redacted. So it's really hard to tell at this point how the court's going to rule or what, if any, records will be unsealed.
Well, I know over the next few months, this story is just continuing to develop because it's been developing for the last few years now. I would love to get your opinion once there's a new chapter in this never ending story. And thank you so much for your time, expertise, and legal insight into this.
Let's talk about it again soon.
Thank you so much for listening. If you found this episode helpful or informative, don't forget to follow us on social media and share this podcast with your friends. Like, follow, subscribe so you never miss a show, and help others know their rights by spreading the word. Your support helps us keep fighting back. The information provided in the Fight It Back podcast is for general informational purposes only and is not intended as legal advice. Every case is unique and should be reviewed by a qualified attorney who can provide guidance based on the specific facts and circumstances of your case. Listening to this podcast does not create an attorney-client relationship with Fight It Law or any of its attorneys. If you are facing any legal issue, we strongly encourage you to consult with a licensed attorney directly.